Hi, I'm Bob Scrivano, the CEO and founder of Assets and Aging, for 30 years helping seniors and the families of seniors find solutions to the issues of aging. Remember, I'm not an attorney, I don't practice law, I don't give legal advice. In fact, everything we talk about here is our opinion only and is based on current rules and regulations. You should always consult a qualified attorney if you have questions, and I happen to be here with a qualified attorney, and his name is...
Hi, I'm Gary Lieberman. I'm an elder law attorney. I've been in the private practice of law for 33 years. The main emphasis of our practice is estate planning, asset protection planning for seniors and their families.
Gary and I want to talk for the next few minutes about trust. You've seen other videos here. We'll be talking about powers of attorney, but today, in this video, we want to just focus on trust. Gary, when most people come in and talk to you, what's the subject that they want to discuss when they come in to talk to you about revocable living trusts or wills?
When they die. What happens when they die? Where do their assets go when they pass away?
So most people, when they're talking to the attorney or the paralegal or the internet or whoever did their trust, what they're really talking about is what happens when I die.
It's death, correct.
But most trusts, however, don't deal with something else. Most trusts don't deal, what I call it is, most trusts don't deal with what happens when the stroke fails. When the stroke succeeds and we're dead, it deals with that issue. But what if I'm incapacitated? What if I'm incompetent? What if something happens? Most trusts don't deal with that, and most trusts don't have what kind of language in them?
We refer to that as frailty language, and that means language in your trust document which addresses what you do if you don't die, what happens to your assets and your estate if you don't die.
And it's really a big difference, isn't it?
Oh, absolutely, major difference.
So let me give you a little example. In most trusts, most trusts have language like this. The power to revoke or amend this trust is personal to the trustors and may be only exercised by them. Now, in layman's terms, what does that mean?
Well, trustors, by the way, are the people that set up the trust. They're also known as settlors or grantors. What that means is no one other than them can sign their name to make an amendment, a modification, or revocation of the trust. It's personal to them, cannot be done through a power of attorney, cannot be done through court or conservatorship.
So if Dad has a stroke tonight, and tomorrow he's completely incapacitated, incompetent, doesn't know anybody, doesn't know Mom, doesn't know Dad, doesn't know himself, that revocable trust just became what?
It just became irrevocable, unmodifiable, and unamendable.
And in our world, that's really important because the ability for the well person to deal with the trust, even if nobody's dead, is what's going to allow us to protect the home and to protect assets and protect everything else, right?
Absolutely. We may need to reposition or retitle or gift or transfer the assets. And in most cases, it takes the signatures of both Mom and Dad in your example. And if Dad has the stroke and cannot sign his name, then we have a major problem.
Also in most trusts, if Dad dies, what does Mom find out if Dad dies to that revocable trust?
The trust just became irrevocable, unmodifiable, and unamendable.
Now, most trusts don't have frailty language in them.
That's true.
And I hope folks listening write this down, get a pencil and paper or something and write down what I'm about to ask you. What kinds of things should trusts have as it relates to frailty language that every trust should have and people should look for in their trust? What needs to be in there to deal not only with what happens if I die, but what happens if I don't die?
Well, there are several different provisions that we like to have in those trusts that are absolutely essential. The main ones are that you allow someone other than yourself to make an amendment or modification or revocation. So either spouse can do it or the successor trustee can do it. The right to make gifts, unconditional, unlimited gifts, even to the person who's acting as the trustee or successor trustee, and the power to transfer the form of ownership of assets. It may be from community to separate, separate to community, joint tenancy to some other form of ownership.
And those powers simply don't exist in most trusts.
In most trusts, those powers, those provisions are totally absent.
So let me ask you one more question. If somebody has a trust that otherwise is a trust that deals fairly well with dying, what would happen to, is it possible to fix that trust as long as Mom and Dad are still around and everybody's still healthy or whatever? Is it possible to fix that trust and add frailty language so that the well spouse or the kids could make decisions and deal with issues if mom or dad became incapacitated or incompetent.
Absolutely. We can do what we call an amendment and restatement to the trust, which will accomplish exactly that.
So it can be done.
Oh, absolutely.
And if people aren't sure what they have, what should they do?
They should consult either one of us. They can call the number that is up on the screen, and we will forward them a free consultation.
So if you're not sure if your trust documents or your wills contain frailty language, call the number on your screen now. The consultation is free. Be happy to talk to you on the phone and get you the answers that you need. Again, thanks for being with us, and make sure you look at some of the other videos that you're going to find on this website. They're chock full of information. Thanks.